welcome to Crime in Court. My name is Heather. This is episode 61 of the Canton Cover Up Commonwealth versus Karen Reed. Today we're going to be talking about the fact that the Commonwealth refuses to speak with jurors after the trial has concluded. And what does that mean? We'll get into that in a little bit, but please hit the like button. I appreciate it. It does a lot for the algorithms and whatever that means. Algorithms are gonna rhythm. So I just wanted to go over really quickly a tweet from Christina Rex. She is a reporter with WBZ TV, which is Channel 4 in Boston. And she posted this on X on Monday. So, Monday afternoon, she writes this. New, the same juror with whom I've already spoken from the Karen Reed trial tells me that they reached out to both the Commonwealth and the defense team, expressing a willingness to talk about the trial. This juror says they have only received responses from the defense despite multiple calls and voicemails to the Norfolk County DA's office. So the DA's office is not responding to these voicemails of this one individual juror. There have been multiple. We've got 5 jurors so far that have come forward and said unanimously we were unanimous on 1 and 3, counts 1 and 3. So um, this is yet another example of the Commonwealth not doing a gosh darn thing about it. So earlier today, this morning, oh, I wasn't done with that. Hold on. So this was Monday. She wrote this about the Commonwealth hasn't responded. Okay. Following day, she writes this post. And I think it's because the Commonwealth may have been trying to do some damage control. Because it says here, the Norfolk District Attorney's Office tells me that there are, quote, parameters on the discussions that they can have, quote, in situations like this with former jurors. But the office would not comment further. So basically, they're saying there's limitations on what we can say and what we can talk about with the jurors, which is understandable. But it doesn't seem like they've even communicated it at all. So, oops, that's not what I wanted. So now we can read this. So this is the Commonwealth's post-trial notice of disclosure. This just was filed this morning, Friday, August 2nd. So Monday, Christina Rex outs the Commonwealth for not responding to the jurors. Tuesday, the Commonwealth probably reached out to her for comment because that's bad PR. So they wanted to tell her, hey, there's limitations on what we can say to the jurors and leave it at that. No more information. So so it kind of takes the weight off of them for a second. But I don't agree with that because um I mean it's their crisis control, but the weight should still be on them. The pressure should still be on them. Let's read through this and you'll see why. So now comes the Commonwealth in the above captioned matter and provides notice regarding the defendant's post-trial claims regarding the jury's deliberations. So I highlighted that because they're saying it's the defendant just making these wild accusations and claims about the jury's deliberations. All right. So it's not just the defendant now that is claiming this. On Sunday, July 21st, 2024, the Assistant District Attorney Adam Lawley received an unsolicited voicemail on his office's phone line from an individual who identified theirself as a juror by full name and seat number. This individual stated, "It is true what has come out recently about the jury being unanimous on charges 1 and 3." So this is now on record. Adam Lawley is stating that a juror told him that. And now that takes away any. Remember this? This was the Commonwealth's opposition to the defendant's post-trial motion to dismiss. This was their line that they said. The defendant's unsubstantiated but sensational post trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. Well, I guess there goes that argument. That was their opposition to Karen Reed's motion to dismiss charges 1 and 3. And the Commonwealth was like, no, there's no legal ground for that. No way. No, there's no reason to charge or to dismiss those charges. But then now we find out the jurors have been contacting the Commonwealth too, and it goes back. The furthest date that they go back to telling us is July 16th. So why didn't they disclose that to the defense? They're required by law to do so, and I'm assuming that they were being reached out to before the 16th. So all throughout the month of July, basically, is when these motions and things and all the rumblings about the jurors have been happening. And I find it hard to believe that no one contacted them until the 16th. I think that there's been a lot that they haven't disclosed to the defense. My assumption, my opinion. All right, so on Friday, July 26th, 2024, Assistant District Attorney Adam Lawley received another unsolicited voicemail on his office's phone line from the same individual who stated, quote, can confirm unanimous on charges 1 and 3 as not guilty and as of last vote 9-3 guilty on the manslaughter charges, which is horrific that 9 people even got to that point of manslaughter on the lower level manslaughter charges. The Commonwealth did not respond to this individual as the Commonwealth is ethically prohibited from engaging in discussions about the jury's deliberative process. Well, actually, Adam Lally, you're not asking them about their process. You're not asking them about their deliberations. You are simply asking, was your verdict unanimous for count 1? Okay. Did you reach a verdict for count 3 and was it unanimous? Okay. Moving on. That's all you have to do is ask these individuals a question like that. And that's a question about the verdict. It's not a question about the deliberative processes and what their thought process was going into it and the things that you're not supposed to talk about. Because there is a law that attorneys aren't supposed to talk to jurors after a trial has concluded. But there are exceptions, and we're going to get into it. So we'll read through those. Excuse me. Where was I? Okay, so the Commonwealth ethically prohibited from engaging in discussions with the about the jury's deliberative process. Similarly, the Commonwealth received emails from 3 individuals who identified themselves as jurors. So now that's 4 individuals have contacted the Commonwealth. Have they disclosed that? Prior to today, did they disclose any of that to the defense? I have a feeling no. I mean, I'm speculating, but I doubt it. These individuals indicated that they wish, so these other 3 individuals indicated that they wish to speak anonymously. On July 16th, the Commonwealth responded to the emails by stating that the Commonwealth would welcome the opportunity to discuss the evidence or the Commonwealth's case. However, we are ethically prohibited from inquiring as to the substance of your jury deliberations. They're using this as a catch-all so that they don't have to find out that, or they don't have to confirm that she was acquitted on counts 1 and 3. They don't want to do that, so they're like, oh, no, 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 no. We can't ask you anything about your jury deliberations. No, 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 no. That would include your individual or your jury's collective thought process. Are you asking them their thought process? No. The content of your deliberations? Are you asking them the content? Well, no, because you're asking them the conclusion of their deliberations or the reasons for your decisions. Not asking that either. So, what is the problem? I don't understand. All right, so it was further explained that the Commonwealth could not promise confidentiality and that the substance of any communications may necessitate disclosure to the defendant or the court. So basically, the Commonwealth is saying dox yourself, come out publicly, or forget about it because they can't promise confidentiality. Even though Judge Bev impounded the juror list indefinitely, they can't promise confidentiality. Why is that? Doesn't make any sense to me. All three jurors declined to further communicate with the Commonwealth and provided no information about the jury's purported votes. I wonder if after this filing, we're going to get more of these jurors contacting the Commonwealth or going to the media because they're sick and tired of not being heard from the Commonwealth. What do you guys think? You think that this might make some of the jurors angry? So, lastly, I wanted to share with you the rules of professional conduct, impartiality, and decorum of the tribunal. So, this is Rule 3.5 of the Massachusetts Rules of Professional Conduct. A lawyer shall not communicate with a juror. So, I'm only reading. There's more to this, obviously, but I'm only reading the things that apply to us right now. All right, so a lawyer shall not communicate with a juror or prospective juror after discharge of the jury if one, the communication is prohibited by law or court, two, the juror has made known to the lawyer either directly or through communications with a judge or otherwise a desire not to communicate with the lawyer, or three, the communication involves misrepresentation, coercion, duress, or harassment, or the communication is initiated by the lawyer without a notice required by law. And we'll talk a little bit more about that. So let's break this down a little bit. An attorney is not supposed to talk to a juror even after the trial's ended and they've been discharged. They're not supposed to talk to a jury if the communication is about the deliberative process that they're not supposed to talk about. That would be what you're not supposed to talk about. But if a juror comes to you and says, "Hey, we were unanimous on a verdict," that doesn't really fall into this part here. All right, so two, the juror has made known to the lawyer either directly or through other people that they don't want to talk to the lawyer. That hasn't happened here. Three, the communication involves misrepresentation, coercion, duress, or harassment. Um, I would say the only misrepresentation is that of the Commonwealth misrepresenting the evidence in this case. Number four, the communication is initiated by the lawyer without the notice required by law. So there is a notice required by law. We're going to talk about that. I'm going to come down here, yada, yada, yada. All right, number three. A lawyer may, on occasion, want to communicate with a juror or prospective juror after. You know what? This is so hard for me to read. I'm hurting my eyes here. That's much better. All right, so 3A. If a lawyer wishes to initiate communication with a juror or prospective juror after discharge of the jury, the lawyer must send notice of the lawyer's intent to initiate such contact to counsel for the opposing party or parties, or directly to the opposing party or parties if not represented by counsel. Basically, you got to notify any other lawyers that are involved in this. And you need 5 days business notice before contacting any juror. The notice must include a description of the proposed manner of contact and the substance of any proposed inquiry to the jurors, and, where applicable, a copy of any letter or other form of written communication the lawyer intends to send. The preferred method of initiating contact with a juror is by written letter. Of course, you want the record. And the letter must include a statement that the juror may decline any contact with the lawyer or terminate contact once initiated. So it almost seems to me like, from reading this, it seems to me like they almost could initiate contact with a juror as long as they give notice to all of the opposing parties. So that would be, the Commonwealth would want to know that, for obvious reasons. So um, you would have to notify them within 5 business days, and the notification or notice has to have all of the things that it's asking for. A description of the manner of contact, the substance of the inquiries, and any kind of letter or communication that you're going to send. You would want that. You would want to include that with your notice. So it almost seems like you can initiate. And if they tell you, I don't want to talk to you, then you have to stop, which is fine. But I don't know. So if the lawyer seeks to initiate contact through an oral conversation, whether in person, by telephone, or otherwise, the lawyer is nonetheless required to provide opposing counsel or opposing parties with prior notice of the substance of the intended communication 5 business days before the contact is initiated. So basically, this is guidelines. You can contact a juror as long as it's not about their jury deliberations, which I don't think that this qualifies. I think this qualifies as a jury verdict, not not the deliberation process itself. So that's my take on it. Number 3B. If the juror, both, if the juror initiates the communication with the lawyer. So if the juror seeks out the lawyer in the case, and they seek to communicate about permissible subjects such as the existence of extraneous influences on the jury, or the lawyer's performance during the trial, the lawyer is permitted to communicate with the juror after discharge of the jury without following these notice requirements. And I could see, because it is about the verdict, why David Unetti and Alan Jackson wouldn't want to seek out that initial contact. They would want the jurors to contact them initially, or um, somehow, put it on good notice and be really thorough in what you want to do to communicate with them, and make sure that it's, the Commonwealth would object to if the defense comes forward with a motion to contact these jurors, which they already have. They've already objected to it. So, they don't want it. But it almost seems like here they don't need the approval. They could go out and seek information, like, was the fact that Brian Albert was in the gallery, was that influential? Or how about the fact that the jury directions were deliberately confusing and contradictory, or things like that, like the extraneous stuff? Maybe a juror was approached by a McAlbert. That you can talk to them about. But when it comes to the jury deliberations, the stuff inside that room, they say it's so sacred, whatever, whatever. You're not supposed to ask any questions about it. But if you're asking, was your verdict this? How is that violating this? I don't get it. Do you guys see what I'm saying? Is it not, I mean, I guess, I don't know. Could I see it both ways? Not really. I guess I could see it both ways. Like they're not supposed to talk about this, but is this an exception? Or are they okay to talk about this because it's not actually the deliberation process that you're asking them about or their thought processes? What were the things that Adam Lawley said? It can't be about the jury's collective thought process, the content of your deliberations, or the reasons for your decisions. Beautiful. If I don't ask you those three things, can I contact the jury? Right? So I don't know. Hopefully, I mean, I know that just to be safe, Alan Jackson and Unetti probably won't do any of the initiating unless they have the approval from Judge Bev because you know how she is. Anyways, I hope you guys enjoyed this. Sorry it's such a short one. We just had an update recently and not a ton of stuff has come out since. So, but I did want to get this to you guys quickly. And I'm keeping an eye out for any response from the defense if they have one. So I will let you guys know if, when, and if that comes in. So uh, please be sure you are subscribed. Hit the like button on your way out. Thank you so much for watching. I'll see you guys in the next one. Take care.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.